All right, good morning, everyone, and welcome to another Tri-County Suburban Realtors virtual seminar. These sessions are brought to you at no additional cost by virtue of your membership in Tri-County Suburban Realtors. So thank you for your membership. Today's session, Fiduciary Duties in Death and Divorce, is being recorded and will be shared to the TCSR webinar archive on our website shortly after the conclusion of the event. We ask you to please respect the time and effort of our presenter by keeping your camera on and your microphone off. There will be time for Q&A, at which time you may unmute and ask your questions. Our speaker today has provided some handouts, which I will drop into the chat shortly. They're mostly for your reference after the class, but I will put them in the chat in just a minute or two so that you can have them now if you like them. So one more reminder to please mute. And then I ask you to please welcome today's speaker, Bill Weber, legal counsel for Tri-County Suburban Realtors and a partner in Connor Weber Oberlies. Bill?
Good morning, Paula. Thank you. First and foremost, I'd like to thank Paula for not only organizing this presentation today, but providing her leadership and her technical support, because without what she has accomplished, I would not be here, which means literally I would not be on the screen. So she is, anything goes well or right, that's largely due to Paula's efforts. And thank you, Paula. I always appreciate the opportunity to get with you guys. I've spent 25 years in representing the association. I value it very importantly as a client, but also realtors as colleagues and friends. What you do is very important, and how you handle things is important not only to the profession and the practice, but to the culture, the society, the importance of how we live our lives here in America. Home ownership is at the foundation of, I think, most of what is important in America. I just heard, is everybody okay? I heard somebody bounce in and bounce out. Maybe it was just a random microphone. There are materials. We've taken some time to put some information together that I think will be useful. I'm not going to lecture from the materials. They are designed to be a tool, a resource for you after today. Certainly look at them as we go through, but my thought was to give you something that you can take with you that will give you a basis in going back and checking things, some of the things we'll talk about today. For instance, a couple statutory authorities that are relevant. The seller disclosure law that is relevant in a lot of circumstances, but will come up in the circumstances we're going to talk about today, and some other literature. When they're in there, there is one typo in the document that I'll correct for you when we get to that point. The irony is not lost on Paula and I. We talked about this before we started, that here on Valentine's Day, we're talking about a presentation founded in divorce and death. I guess it's also the first day of Lent, so maybe from a penitential standpoint, we'll approach these things carefully. What I want to do is to guide you through what I think is a cogent analysis of the circumstances that will arise as professionals taking your clients through a transaction that may not be a typical transaction, namely a transaction where legal elements intercede, the death of one of the parties, or both of the parties perhaps, and or a divorce proceeding that has commenced before the transaction or is entered after the transaction has begun, because there are circumstances that may be a bit different. What we are dealing with is a level of interaction then between the legal process and the transactional process, which you guys are all very familiar with. And I'm sure a lot of you have dealt with over the years with transactions that have involved death and divorce. I can tell by some of the faces and names that I do recognize that a lot of you folks are very experienced, and there's some things you're going to be able to share with us that are going to be helpful to all, including me. For the good of all, there's some fundamentals that I'll address going through each of the categories, namely both divorce and decedent's effects, the effect of a death, that a lot of you may have heard before or may be familiar with. please bear with that because I think it's important to provide some background in each area from a legal standpoint. But first and foremost, what are we dealing with? We're dealing with, in a transaction now, the interplay of those legal elements that create or give rise to the involvement of a fiduciary and fiduciary duties and responsibilities. Simply put, a fiduciary is a person who, by agreement or by order of court, is charged with the responsibility to act in the best interest of another. So in other words, they're there, that person is there, that entity is there, but the legal charge to that person or entity is to care for the well-being of another individual, namely one of the parties to the transaction. How does that arise? Well, you sign off on a document and agree to it, or you apply to the court for authority to be able to do certain things, and the court will appoint you in certain capacities. And those individuals so appointed, and we'll talk about who they are and what they are then responsible in a fiduciary level to act in a very careful, reasonable way for the benefit of another person, a person that is perhaps no longer with us, or at least not present physically in the transaction as we're going through it. So it's important to recognize that and to make sure that when you are approaching these transactions, you are dealing with somebody who has that fiduciary, not just responsibility, but authority. So our key concerns are to understand the transaction, number one, to identify the parties. Who are the parties in interest? Typically, we're looking at an agreement of sale. We're looking at a representation arrangement. The party will be denominated. That person's name will appear on those documents. That individual might change. There's the reality that there's a divorce involved. Now maybe you've got more than one person who has to be considered. A death. The person that you started with isn't around any longer. There's someone else who's stepping into that person's shoes. So not only understand the transaction, which you're all very good at, and we're trained to do that, but you have to have a clear understanding of who the parties are. Thirdly, the authority. Who has the power to go forward and initiate this transaction and complete the transaction, which is kind of the goal. That's the touchdown we want to get to. We want to get to that goal line of having the transaction completed. So are we dealing with the people that have the correct authority? Usually that comes to light, but you don't want it to come to light last minute or in a bad way. So there are certain rules I'm going to suggest to you as you approach these things. First, as you enter into these transactions and you recognize that you're diagnosing something a little bit different here. You started with a person as the seller. All of a sudden, that person's not showing up. Perhaps they're not well. They're not involved. They're not engaged. You're dealing with somebody else. Well, who is that person? Do they have legal authority? Are they a power of attorney, which in legal terms is called an attorney in fact? They've agreed. They've been asked to, and they've agreed to act on behalf of another. What do you do? So be sensitive to that change. Any change in circumstances can be really important. Given that, there are no foolish questions except the ones you don't ask. If something doesn't look right, sound right, feels different, ask. Raise your hand and say, Harry, it's nice meeting you. Last time we got together on this project, I was talking to Mary. I was talking to someone else. Can you tell me, Harry, what your involvement is? You know, they're not going to say, I'm the next door neighbor. They should be saying, well, I have a power of attorney for Mary, or Mary has gone to heaven. Mary's no longer with us, and I'm acting on Mary's behalf. Okay? Be sensitized to those changes. Next, and probably most importantly, be prepared. in situations where there are any legal implications, the devil is always going to be in the details. Be conscious of any change that occurs and ask yourself, does that matter? How does it matter? How do I deal with this? Again, don't be afraid to consult a higher authority. Talk to an experienced professional in your office. Talk to the broker. Contact legal counsel. And the handout that you're going to be getting, my name and number is there, and also the name and number of the young attorney in our office, Pat Casey, who's very bright and very capable and took most of the time putting this package together. His phone number and my phone number are there. We'd rather deal with you, helping you to stay off the rocks, than after the ship has crashed against an impediment and we're trying to sort things out. So issue recognition, sensitivity to questions and concerns, raise your hand and ask. Start with the parties, start with experienced people if you wish, because you're going to find them at easy access, but don't be afraid to call us and say, hey, Bill, this just happened in this deal. This is what I think. How does that make sense to you, or does it make sense to you? And we'll talk it out, all right? Know your toolbox in terms of being prepared. The next thing is first details. Secondly, you have an excellent set of documents that you're very familiar with. I have 2 kids who are realtors, and I tell them the same thing. Essentially, I tell the young attorneys in the office, beginning of every year, they look at me like I have 2 heads, but take out your toolbox. For the lawyers, that's the rules of civil procedure. For my kids who are realtors, and for you guys, it's take out that agreement of sale, that listing arrangement, that agreement, the seller's disclosure, the things you're going to use, and read them all. Make sure you're comfortable with every aspect of it. Look for changes. Ask about those changes, but know your toolbox. Know what that agreement says and does. For instance, we're going to talk a little bit later about changes in the parties. Well, sometimes those changes are apparent and sometimes they're subtle. Suppose your agreement of sale identifies the buyer as John and Mary Smith, the survivor of them, and or their heirs, executors, successors, and or assigns. What does that mean? Is that a change that's significant? Is that something that you've discussed with your client? Be sensitized to what the agreement says and does for you in its base arrangement and what changes may be made to that. You only do that if you know the agreement so well inside and out that you're facile with it. You're the expert in the room when it comes to that document. You're not giving legal advice, but you're helping people understand how the transaction.
Right after your fall?
I'm sorry, oh, thanks, Tom. Okay, so that's our overview. Now we're going to deal with some of the nuts and bolts of circumstances. Let's talk about, since we are on Valentine's Day, we'll try to deal with the issue of divorce and get through that on a fundamental way, in a way that may make sense. Divorce is one category of what attorneys would classify as the law of domestic relations. There are a number of other categories that are all very important, but divorce is just one of them. What is divorce? Divorce is the legal implications and involvements that surround the dissolution of the civil, legal, marital relationship, whether you're married or you're divorced. Pennsylvania, as you guys know, no longer recognizes common law marriage. So, the legislature has made that determination a lot easier for all of us. You either are married or you are not married. Having said that, there are levels of involvement legally that can exist outside of marriage and that may persist during the course of the divorce proceeding until a divorce is entered, if at all. In Pennsylvania, there are two ways to accomplish a divorce: on a fault basis or a no fault basis. The vast majority of divorces are accomplished as no fault matters eventually. There can be a lot of animus, as you might expect. The most important relationship, the closest relationship most of us have, is coming apart. That's the nature of the divorce. So they can be contentious. That tension, that contention is often translated to everything, including a transaction that may involve the disposition of the home. From a practical standpoint, if two people in a relationship are going through this process and one wants to be out of it and the other perhaps does not, or at least does not at a juncture, ultimately, if the person who wants out persists, a divorce is going to be entered. The reality, the practicality of the circumstances are also that it's much less painful, quicker, and a lot less expensive if a divorce can be accomplished on a no-fault basis. Now, under a no-fault analysis, there are two ways that it can be accomplished. One is by the mutual consent of the parties, and the other is based upon a continuous period of separation. I believe it's 3 years. Typically, eventually, people come to terms with circumstances and they agree to a consensual divorce. But saying you just want a divorce and agreeing to that does not get you divorced. Now you have to look at all the relationships that are affected, that bind that couple together, and they involve spousal support, alimony, and for our purposes, most importantly, in terms of what we have to worry about, equitable distribution. Equitable distribution is the division of the property of the marriage, assets and liabilities. Okay, so you can have one column that can be very strong in terms of the assets. Usually that's where the house may reside, but there are liabilities, mortgage against that house, other debts and judgments. Where do they exist? How are they secured? Okay, so if a couple says, well, we've agreed to a divorce, okay, that's great. You're on your way to where we need to be, but you have to understand, and they have to understand and should from their attorneys, not from you guys, that that means coming to terms on what is equitable distribution. Now, there are two ways that that can be accomplished. Equitable distribution can be, and hopefully will be, the subject of a detailed agreement that's called a property settlement agreement, where the business of the marriage, the assets and liabilities, among other things, is discussed and a plan of distribution, excuse me, laid out and established. That plan may or may not be approved by the court, but at least if it is contractual, that is to say the parties have signed it and it's been appropriately reviewed by their counsel. If there's one attorney involved and on one side and not one on the other side, alarms need to go off. It doesn't mean it can't happen, excuse me, but it means you've got to be careful. They should be very careful in what they're doing under those circumstances. That care has to translate into how we approach the transaction as well. But they can agree to the disposition of the property, what's going to happen and when, in an agreement, a property settlement agreement. If it's not in a property settlement agreement and they have to litigate, maybe not the reality of the divorce, they both agree that they will consent to a divorce, but they can't work out the nuts and bolts, the dollars and cents of this. They may be forced to try the economics of the relationship. That is basically a trial for equitable distribution only. And at the end of that process, there would be a court order or a decree. which would lay out exactly what happens. And what we're interested in, of course, is what's going on with the property, who's getting the property, who has the authority to act on behalf of either or both of them respecting the property. There are often discussions, and I will say that the more experienced domestic relations attorneys that I've worked with over the years, if they know this house issue is out there, and for some people, it's the major asset. I mean, the retirement account and the house are typically the two biggest things that have to be considered on the plus side. There can be a world of debt, which is another issue, but on the plus side, what goes on with those assets is very, very important. And you'll see in the property settlement agreement, and sometimes in the divorce decree, usually the judges aren't going to get bogged down in this, but there will be a discussion about who's going to be the agent. They'll say something to the effect the parties agree that Mary Jones will be selected as the listing agent for the property, and both sides will cooperate in those efforts and behave reasonably. You know, maybe good luck, but that's what can happen in the agreement. So seeing that agreement is going to be very important for your purposes. So if you're coming down, you know, the alley on this thing, and you start the process and you're representing one or the other or both of these people, buyer or seller, you need to understand who can act, and that's going to be established in that property settlement agreement or the court order. Typically, not always, but typically. Okay. What also occurs as a practical matter is the wheels of justice turn very slowly, guys. Maybe some of you have dealt with that both in personal and professional practice. It gets into a courtroom eventually, and it's not a horrible place to be, but it's the time, the torment, and the expense in getting there that is difficult for all of us, the professionals who are responsible for guiding people, but also for, more importantly, for the people involved. Be aware if something looks like it's heading in that direction as a result of a divorce, and we'll talk about decedents matters shortly, it's going to add more time, almost of necessity, into the transaction. So be aware, make your clients aware, talk to your counterpart if appropriate, and talk about building the time necessary into this transaction, or you're up against the clock in ways that you wouldn't expect to have been. Excuse me. So the impact of divorce is significant. The litigation of divorce is very a la carte, as I've mentioned. You can have litigation on the divorce itself, and that is whether or not the marriage continues because they couldn't agree. On custody, which should not affect us, but will affect your clients greatly. On support, on alimony, and or on equitable distribution. Usually not all those things are litigated, but some of them are. And it's very issue specific when you get into a courtroom on those things. And you've got to be aware of that and be conscious of what aspects of the divorce affect the transaction and from what perspective. The important documents. If there is a divorce situation, there is a complaint in divorce that starts the process and an answer to that complaint. You don't need to have that in your file, but you need to be aware that it's out there because the complaint is the roadmap that the court will use in terms of identifying the issues. If for some reason, and I can't imagine how it would pertain, a couple has a house, but they haven't asked for equitable distribution in the complaint, the court's not going to call them and say, hey, your trial on the house is starting next week. Nothing will happen on that. The parties have to be aware that they've got to raise these issues or come up with an agreement and documentation that solves those issues, where you're not going to be able to get through the transaction. Court orders. You want to see the court orders. You don't need to see a court order for child support. That's probably not something we need or want to know, or frankly, child custody. But any court order that addresses or affects the disposition of the property, you need to be aware of. Now, I will say to you that if you're helping a client address their ability to acquire the property, and there is a support order, perhaps out of a prior relationship or a dissolving relationship that goes to support and or alimony, that's going to be very relevant. So the one caveat to the not needing to see the custody or support piece, people need to understand, and they usually do, but I've had circumstances of, oh, I didn't know they were going to ask for the support order when they let me know whether I can get a mortgage or not. Yeah, they are. They're going to want to know about that. The bank needs to know whether there is money going out on a priority basis to something other than possibly them on the mortgage. Okay. So you may need to see orders in terms of support and alimony under those circumstances. We talked about the property settlement agreement. If there is one, very, very important, maybe the single most important document you're going to need to see for our purposes in helping them get through that transaction. There are times where people will say, yeah, Bill, there is a property settlement agreement, but I don't want to give it to you. It's got personal and private matters. We've both agreed that it won't be disclosed. We're going to keep it confidential, so I'm not giving it to you. Your answer needs to be, I need to have certain information from that. I won't make a copy of it. I need to go over it with you, and I may need a copy of certain pages of it, like the page that talks about the house and the disposition of the house, like the page that talks about retaining a specific representative, like the page that talks about if and when the house is sold, what happens to the proceeds, and the signature page to show that the parties agreed to it. So there are ways through that process. Usually if you get to the divorce attorney, they're going to understand that, and they're going to be your ally in working with that. People are sensitive to these kind of things, and justifiably so, and they may not think that we need to see them. We don't want to be cavalier with it. We don't want to see it because we're curious. We're not, but we need to see it because we're trying to help them accomplish what they've hired us to do. You also need to know whether there is a divorce decree. Why is that important? Well, it used to be in Pennsylvania that you could get a divorce decree without having the equitable distribution resolved. In fact, at one point, there were only 2 counties in Pennsylvania that would permit that. One was Allegheny, Pittsburgh, and the other was Delaware County, right down in our hometown in Media. They felt that if you basically get people divorced, dissolve the marriage, they'll be nicer to one another and more civil in working out the economics of the relationship. I think that was a kind of a mixed bag of results, but ultimately, both of those jurisdictions changed, and now the rule is you can't get a divorce decree unless and until all the issues incident to the divorce have been resolved. So the decree is your confirmation that these guys have worked everything out. If there is no decree, there's something out there that's the hanging chad. Perhaps it doesn't affect us, but maybe it does. If the hanging chad is they're fighting about what the split is at the table when the house is sold, if the hanging chad is spouse A doesn't have to leave the property until the custody arrangements are completed and approved by the court, we've got some issues in terms of transaction or access to the property, or perhaps both. So the decree having been entered will be confirmation, and you don't necessarily need to see the whole decree if you're getting the property settlement agreement. You may see a decree that says the property settlement agreement dated February 14th, that would be a sad circumstance, is incorporated in the divorce decree. What does that mean? That means that this couple has worked out the terms of the divorce in every respect, and one of them, or perhaps both of them, have said, we not only want this to be contractual, that is, an agreement that they both sign, but we want it incorporated in the decree of divorce. What does that mean? It means it has the force of law. A decree of divorce is a court order. It means the judge is saying, this is what's going to happen. Judge will say, the parties agreed to this, but I, as the judge, am saying, I want these things to occur, and I'm directing that they occur. It gives more force of law. Excuse me. It also means that if that agreement has to be enforced, a party that does not comply with that agreement may be in contempt of court. So it's not just a lawsuit, a civil suit on breach of contract. It can be an action that the court would be asked to be involved with. It would hold one party or the other in contempt. Doesn't involve us, but it's, if you see that in there, that's why it's in there. It may be an indication, it's usually one of two things: a very, very careful domestic attorney, and or there's been a problem going through this in terms of somebody's behavior, or at least one side or the other perceives that. Let's hope for the high road, and that is everybody's just being really careful, so they want to have that extra layer of enforcement, and it applies equally. Either side can look to that enforcement. So hopefully that gives you guys a bit of an overview in terms of divorce. There are some practical things that come up. Let's take one step back from the divorce, and this is kind of a neutral structural thing, and it's a transition to where we will go with wills and estates. The use and notion of a power of attorney. I'm sure you've all seen that. I'm going to ask you guys for a show of hands. In the last couple of years, where a power of attorney has been involved, has the title company asked for an original and filed that original of record before the deed is prepared and issued? Who has seen that in the last couple of years? Okay. At one time, that was extremely standard. That was the general rule. I've been surprised over the years that that hasn't been the structure that's employed in each circumstance. But where you're dealing with a transaction where there is a power of attorney, be aware that the title company, who is driving the bus to a certain significant degree as we come down the home stretch here, may want that to occur. They may want an original. They may want that original recorded either by them or in advance of the transaction. For our purposes, I want you to check on that, because you also absolutely want to read it. The worst feeling you can have is seeing it the day of or the day before closing, and it's vague or questionable as to whether or not this POA conveys the right or the authority to do something with this particular property. They can be that specific. I appoint Paula Tanzi, my attorney in fact, for purposes of transacting.
Please send me an email and I will look up the name. It was really excellent. I loved it. But I can't remember the name. So
I'm sorry, I only got part of that. Okay, maybe they weren't talking to us. Okay, so if there is a power of attorney, look at it, read it, check it out, get it over to the title representative. That person may be comfortable with exactly what it says. That person may need or want to get it to counsel for the title company or somebody, up the food chain at the title company. You just want to make sure it's going to work and do what you think it needs to do, okay? Otherwise, when you're dealing with the divorce situation, you've got to be really conscious of who needs to act. Again, you're dealing with folks who have been in the closest of possible relationships. Maybe they're both on the deed. Well, that's your guiding light. You need both signatures, and you need to politely, not disregard, but help the person who says, "Oh yeah, Mary and I are both on the deed, but all you need is my signature. I'm going to be getting the house." Nah, humor me. I need to get both of you to sign off on this. Let's talk about the seller's disclosure. The seller's disclosure is a back to basics document. And by that, I mean, whoever is the seller, whoever is identified on the deed as the seller, as the owner, has to complete the seller's disclosure. It may be that the other spouse is living there. For estate planning purposes, particularly on the main line, you'll find often that a property will be in one name or the other and not both. Maybe Ed's living there, but Mary is on the deed. Well, if Mary's on the deed, Mary's the seller. You may want to get information out of Ed about the condition of the property. You may want to have a conversation. Hopefully they're cooperating and being civil about things with both of them there. But the person who absolutely has to sign that disclosure is the seller. And if they want you to go in another direction, you need to politely kind of steer them back to that reality. Have you guys gotten the handout? There's let me just do this before I forget. On the first page, there is a typo. See the bullet points toward the bottom? There are 3 of them. The second one says the owner's spouse may claim not to know about any issues with the home. That should say the owner, O-W-N-E-R, not apostrophe S or whatever else is after that. It's the owner's spouse may claim not to know about any issues with the home. So shouldn't the other spouse fill it out? And the answer, of course, is no. It's the owner's spouse that must fill out the seller's disclosure. Okay. All right. I'm expecting that I'd like to get through everything, and then we'll circle back with questions on all areas and open up the floor to those. But I want to make sure that I've at least covered, again, from perhaps 10,000 feet, the notions of divorce and how they are going to be important and specific questions, and then also estate-related matters. Kind of the same concepts and principles in terms of preparation. You know, be a Boy Scout, be prepared. But there are other issues, and then we'll take questions with all of us engaged in that process as to both areas. Is that a fair approach? All right, thanks, guys. All right, let's talk about some fundamental concepts in estate law. There really are a couple ways to look at this. We talked about a power of attorney. No, and I've had young attorneys who weren't aware of this. I guess they were either absent that day in school or weren't paying attention. A power of attorney is a very important and powerful document, but it, by its terms, becomes a nullity upon the death of the grantor of the power. So the person that establishes Bill Weber as his attorney, in fact, when that person passes away, the power of attorney is a nullity. I can't use it anymore. The other way they become a nullity is by the simple act of Paula Tanzi saying, here's my new power of attorney. I revoke all prior powers of attorney. And what I put in them is including, but not limited to, the power of attorney dated XYZ by which Bill Weber was my attorney, in fact. So there's a clear extension, termination of that power of attorney. Now, what's a little bit difficult and what troubles people in my own family said, well, wait a minute, if I sign this for you, you have the authority to do things for me. And yeah, I understand I can terminate this, but suppose the person that you deal with doesn't know I've terminated it, and I don't know. You're going out to buy a red Cadillac and put it on my bill, which, depending on what the power of attorney says, you could do. So there's some discomfort about how these things can arise and how you get rid of them. They are very, very powerful documents. So be conscious of that for your own use of them, but also be conscious when you're dealing with these transactions. Now, if it is effective and appropriate on its face, unless there is some reason acting in your reasonable and intelligent approach to the transaction that you're saying this doesn't make sense, you're permitted to accept that at face value. That is competent proof of this individual's ability or authority to act for mom or dad, for instance. A spouse, you do want to ask whether or not they are in a divorce. Say, please forgive me, but my attorney wants me to check on this. I have a power of attorney you're acting for in your own capacity, but also for your wife. Is there any present or outstanding divorce proceeding that's involved? So power of attorney is important, it's effective, but be alert. The other document that does not involve necessarily death is a trust agreement. The property could be held in trust, or a trust may arise at the time of death and then be the responsible instrument for transferring, controlling, caring for the property. So if there's any trust arrangement affecting either the person you're dealing with or the property, you need to know about that. Now, the obvious and easiest way is you look to the title of the property, and if the property is titled in the ownership of a trust, well, there's your, your lead for your next question. Okay, the trust owns this property. Do you have the trust agreement? Who has the trust agreement? I need to see the trust agreement. Well, why? Because you need to know whether this person can give you marching orders or not. Are they the trustee? What are the terms and circumstances in the trust agreement that govern the disposition of this property? It could say, under no circumstance may my trustee ever sell, encumber, lease, lien, or otherwise affect the property. Well, then, Harry just wasted his time coming into your office because Harry doesn't have the authority to do anything. So if the property's in trust, ask for the trust agreement. Know what that does or doesn't do. You're going to need it anyway. If you get anywhere near closing, the title company, unless they're completely asleep at the switch, is going to want that trust agreement. Okay, and verification that it's true and correct, and all that jazz that comes with it. All right, so they are the circumstances that may not necessarily involve death: use of a power of attorney, application by use of a trust or trust agreement. Someone dies, and we'll put aside for a moment whether they've died before they come to you, or you've had 2 or 3 meetings with them, you've signed them up, and then sadly they pass away mid-transaction, a buyer or a seller, because the circumstances are going to be a little bit different with each one. Your concerns are going to be a little different with each one, okay? Someone has passed. In Pennsylvania, we recognize both testate and intestate succession. What does that mean? Testate succession simply means when I died, I had a will. There's a document that sets forth the roadmap, appoints an executor or an executrix who is a very powerful person. If you, in most estate planning packages, if you guys have gone through an estate plan with an attorney, typically they're going to prepare 3 documents for you, maybe more, but 3. A healthcare power of attorney that talks about what needs to happen if we become unable to speak for ourselves in perhaps a final illness context. a power of attorney where you take the person that you trust most in the world and say, this person can act on my behalf. Good thing to have as our parents get older, as we get older. I've got 4 kids. I love my sons to death, but my daughter has power of attorney because she was the kid that did her homework, that was organized and got things accomplished, and still does. So, you know, and we trust them all, but Kate's going to be the person that if I can't get to the bank and need something done, I know Kate will get there. The boys may or may not, or may get there a couple of days later. So that's an important person. We talked about the trustee. We're going to identify an executor or an executrix. The power of attorney will take authority to act up to the point of death. At the point of death and forward through the administration of the estate, the executor is in that bandwidth and has control of what needs to be done. Both of these people, go back to our title for our seminar, are fiduciaries. They are charged by the court as a matter of law and by agreement to act in the best interest of that individual who conveyed that authority to them. If they step out of line, there's a world of trouble that can land on them. When somebody asks you to be power of attorney for them, think about it. That's a big responsibility. When somebody asks you to be their executor or executrix, think about it. That means everything from going to the courthouse and getting the estate established to cleaning out the 500 pounds of magazines, books, and papers in their attic, you know, and everything in between. They're big responsibilities, and you are charged legally with acting in their best interest. So too is that person who shows up either in the first instance and says, Corey, I want you to help me sell this property. It was my aunt's property. Well, the next question, after you say, I'm very sorry for the loss of your aunt, how are you doing this? What is your authority? If the will makes that person the executrix, she has to then take that will and the death certificate and forms of identification and a check. And depending on how the will's drawn, perhaps witnesses to the will. Wills can be what is called self-executing. If it's done properly, and all the attorneys in the neighborhood around here are going to do it properly, you don't need to take the witnesses in. But if you get a really old will, or a will that somebody wrote on a paper bag, which can be valid, holographic wills are still recognized as valid. The witnesses, it may not be self-executing. Self-executing means a notary was present, asked these people whether they understood they were witnessing a will. Did they see Harry sign the will? Did Harry express that he was signing his will and not, the laundry list or the shopping list for the supermarket? That's done. They don't have to do it again. You have that self-executing document. You go to the courthouse. But that executrix has to have done those things. Why? Because the court has to approve it and issue what are called letters testamentary. She'll have a document that has a fancy gold seal on it that says letters testamentary have been granted in this matter to Mary to act as the executrix for the estate of Harry Jones. If they don't have that document, you got to help them understand that they've got to go get it. People sometimes think if they have the death certificate and the will, we're good to go. Where do we start? Now you got to back up a little bit. You got to get the estate organized. Getting the estate organized usually also means setting up an estate account, getting a tax ID number for the estate. Again, building time into this process. The other way, now somebody dies without a will. Does that mean nothing can happen? No, not at all. A lot of people pass without wills. The process is a little bit different, a little bit more court-driven. They're overseeing it a little bit more closely because this person now hasn't expressed what they want done, nor have they identified somebody to act in their behalf. That is an intestate matter. Intestate simply means they died without a will. What do? You try to find the closest living relation who is appropriate for this purpose, or the family should be doing this. If the person coming in to see you is the fifth cousin twice removed and hasn't seen the decedent since they were kids at the shore back in 1965, you may want to ask, is there anyone else that was closer? Or why is it you? That may be the closest living relation. Typically, it's going to be spouse. It's going to be parent-child type of circumstance in either direction, sibling circumstance. The court is looking to who's the logical person here? Who's the person most likely to do this, knowing what the decedent wanted done and being careful about it. Qualifications and credentials matter. Well, I am the second cousin, but everybody else is over 75 years old and not able to get out and around. There could be reasons why it's not the next of kin closest in line. But that person then is appointed, and there are what are called letters of administration. That means that this person is appointed the administrator or the administratrix, who has then the same authority, fundamentally, that the executor would have in handling the estate. What do? They take the will, they raise an estate by going to the court and getting approval, they set up an account, and now their job is to gather everything into the barn. All the assets come into the barn, they have a list of them, they're going to have to file either whether there's an executor or an administrator, they're going to have to file under Pennsylvania law an inheritance tax return. The standard is 9 months from the date of death. As a practical matter, they routinely provide extensions. But again, you need to know this because that's time that can be built into the transaction. There is a tax that's imposed unless the transfer from husband and wife is exempt under Pennsylvania law. But if you're transferring it to the kids, to parents, to other relations, or to non-blood relations, friends, there's a tax that's due. Pennsylvania doesn't miss that. They're looking for that. They want to see the inheritance tax return. How does that affect us? Well, you're coming down the pike, you're getting to closing. The estate's going wonderfully. Everything's been liquidated. The inheritance tax return has been filed. You have approval of that inheritance tax return. Well, what's that? Pennsylvania only sends out a notice. It's called a notice of tax due. If the notice of tax due comes back with zeros on it, that's all you're going to get from Pennsylvania. It's telling you that the decedent's estate paid all the tax that was owed, or whoever was responsible, sometimes it's not the estate, paid all the tax that was owed. There's nothing else that's due from the Commonwealth standpoint. Why is that important? Well, if you transact the property and you don't have that, the Commonwealth comes back around and starts looking for where the money is. They can't get it from the estate. They show up on the doorstep of the people that are now in the house. Now, whether they get it from them is another matter, but you need to be aware that that's a problem. Typically, the title company is acutely aware of this. They know now we've got somebody's passed either before this started or during the course of this transaction. We've got to deal with this. They're aware of it. They're looking for that notice. But you guys should be conversant in that as well. You should know that it's available. Are you dead in the water if it's not there? Not necessarily. Title companies may ask for an escrow. They'll ask for a copy of the inheritance tax return. they be told by their counsel, well, don't assume that it was right. Probably is right, might be right, who prepared it. They may even call the attorney who prepared it. But what I've routinely seen is the title company asking for an escrow of 2 times the amount of any tax that would have been due or showing as owed under the tax return. And that stays in escrow until that notice comes out, and then everybody shakes hands and goes their separate ways, and the money is paid where it needs to be paid. But where there is a decedent involved, you have that extra layer of complication. Now let's talk a minute about some of the fundamentals that can be significant in terms of the will and estate aspect of things. We talked about the power of attorney. We talked about the will, the trust agreement, the grant of letters of administration, grant of letters testamentary. There are other things that create specific authority called a short certificate. Short certificate is just a simple short form that says Mary Jones has the authority to do what it is she's doing by order of the court. You may want to have a couple of those. And if your representative is at the very beginning of the estate, they only cost a few bucks a piece. It varies from county to county, but they're pretty cheap. Get a bunch, because somebody may surface 5 years later and ask for something to be done. And if you don't have a short certificate, you got to go back to the court and apply for more. You'll get them, but it's a complication and delay you don't need. We talked about the inheritance or estate tax return. Understand there can be a whole nother layer, which we're not going to get into today. Depending on the size of the estate, the federal government comes kind of skulking around. There is an exemption that we all have that's been graduated up year to year to year. I believe it's like 11.5 or maybe $12 million a person at this point. So it's usually, you know, if people owe that amount of money on the first person to die, that's a significant estate, and you could be dealing with that. Usually it becomes relevant on the second, if at all. But if the estate is higher than that exemption level, a federal estate tax return needs to be filed. This is why estate planners are very busy people all the time, but particularly now. The federal estate tax rate starts at 40%. So it's not a tax you want to pay if there's a way of legitimately avoiding that tax. Estate planners do all sorts of things, separating out assets, which may affect how a deed is held for that reason. They also are moving money to trusts, again, something we should be conscious of. I mention it for those reasons, but also because the present law out of Washington has a sunset provision, I believe it's 2025, where the threshold per person is going to drop down to 5.2 million, somewhere in that range. So all of a sudden, if the law isn't changed by whoever is in power at the time, and you know, you kind of look at the dysfunction that we see in Washington at this point, it's conceivable that these folks won't get together on any kind of compromise. And now we're dealing with a law that says by its terms, at 2025, this one's gone, and you go back to 5.2 million. All of a sudden, a lot of estates are going to be subject to that federal estate tax requirement. That means another return. That means another proof that the taxes have been paid and satisfied as being relevant to the dissolution of any property. And you can sell the property, but the property, the money that it's turned into can't disappear. Maybe the outcome. Get counsel involved. Not necessarily acting for you, but you need to talk to the attorneys on this estate, the attorney for the heirs. Okay, where are we on this, guys? I need written assurance that this is accomplished, and I need you at my shoulder talking to the title representative so we can transact this property. All right. couple variations that are going to sound a little confusing, but let's talk about a couple differences. None of us are going to know the time or the hour, I suspect, of when we're passing on. Like some people have an idea, God forbid, a difficult illness. But someone may pass before the transaction's commenced. Someone may pass during the course of the transaction. If you have a buyer and seller, and the seller passes after the transaction, after the agreement of sale has been signed, the seller's estate can be legally and will be legally compelled to complete the transaction. That is a valid and binding contract that obligates the estate. If the transaction is documented, there's an agreement, and the buyer dies after the agreement of sale has been executed. Completely valid document. I'm buying a house and I walk outside and I get hit by a truck. What happens? Can you complete the transaction? The answer is maybe. Why maybe? Well, first thing you do is you go back and look to the document. If the document says the buyer for himself, his heirs, assigns, successors, commits to buying this property, then a very good legal argument can be made. Yeah, Bill's intention was to buy this, and if he couldn't buy it, he wanted his family to have it. He's committing to doing that. So you have a good argument under those circumstances that the property should be conveyed. If it doesn't say that, the buyer is likely at liberty to be out of the deal. You'd get an executor for me that's saying he didn't obligate his estate. Clearly, he wanted to buy this himself, but only himself. So we want out. Are you left without recourse as the representative for the seller? No. There is a statute in Pennsylvania that I've included in your materials that permits specific performance. It should be the last page. And that statute, which is 20 PA CS Section 3390, specifically relates to the transfer or transactions involving real estate and says the court may, upon request, order specific performance. What is specific performance? Basically, it means you're going to the court and saying, Your Honor, we want you to order that this transaction must be completed, and here's why. And then there's back and forth as to what that involves. Doesn't happen often. It is a legal but quasi-equitable remedy. In other words, the court is permitted to look to what is fair under the circumstances. I will tell you that I've been involved in very, very few of these kind of things in the 44 years I've been practicing law, but I will tell you that none of them has ever been enforced where there are contingencies that are personal to the buyer as an individual, like a mortgage contingency. You know, you're basically saying, we're going to order that this transaction occur. Bill Weber's gone. His ability to apply for a mortgage or get the mortgage now that he's expired is non-existent because the bank ain't lending him the money. He's not there. His job's out the window with it too. And the kids don't have the wherewithal. Well, the court's not going to order the specific performance of that contract in most circumstances. And only rarely would I see it happening. But if you're representing the seller and the buyer dies, you may want to consider whether your client wants to push the agreement a little bit, at least, to see what's there. Okay, you're obviously in better shape if it says buyer, his or her executors assigned, successors, yada, yada, in the agreement. Usually agreements for a residential real estate transfer don't say that. you can add it. So I've seen forms that do include that, but be conscious of it. Why? I wouldn't worry about the getting hit by a truck circumstance. I would be aware and alert to a couple that's coming in that are, my mother-in-law is 95 years old. She still talks about wanting to buy a place in Florida. I'm cheering her on personally. But if that person wants to buy a property, it would be a fair thing to say, Pauline, you're 95. If something happens to you before this is completed, what do you want to have happen? Okay. If the seller dies and when they die, okay? You may be able to get it through easily. You may have something that's going to go away as a practical matter if the buyer has passed. That's likely, I did more often than not, but not necessarily all the time. Does that make sense? Have I thoroughly confused everybody sufficiently to the point that maybe we want to start asking some questions?
I have
Paul,
a
are you
question.
there?
So my question is, how would a real estate agent get leads for divorcees?
Get leads?
Yes, like how can I get in the realm of knowing who's getting divorced and who's not if they're not in my personal sphere? Is there a way to get a list of people that have recently been divorced?
It's typically not something that the court would publish. The divorce docket at one time was a relatively sealed record. That's a great question. I don't think there is a list of divorcees that you can, or people that have filed for divorce that you can get from the courthouse. No.
Well, there are services you can sign up with and pay a subscription for that'll help you out with that. But yeah, it is public record once they start the court case.
What services, if you know any?
I don't know. What area do you work in? I don't know. If I want to answer that
Philadelphia.
Yeah, I would just Google it. There's plenty of services out there.
There's
Bill,
a
it
hand.
looks like Dominic has a question. Dominic, do you want to unmute and ask your question? Thank you.
Hey, Bill. Hi. Great program, Bill. Thank you. On behalf
Thank
of
you,
everyone.
Dominic.
We had a situation that almost came to fruition, but it didn't, and we never got the right answer. We had divergent legal answers, so I'm going to put you on the spot. We had a seller a few days before settlement who was dying, and the seller signed the deed package. And we were wondering whether or not the title company would settle if he, in fact, died before the moment of settlement. He fortunately lived beyond that moment and everything went okay. But could a title company settle the property if the deed has already been signed by the seller, but the seller is no longer living at the time of settlement?
Pennsylvania is a statute that requires not just the execution, but also the recording to transact it. So while I think you could have a divergence on this, I think the more cautious, the better approach would be it's an escrow document that is not effective unless and until the document is recorded.
So we would have had to delay, if we did that, we would have had to delay settlement and probate the estate and get an executor to complete settlement.
Raising the state. I think that would have been the careful approach, Dominic. Where the rubber would meet the road is what the title company was willing to do. If the title company would insure it based on the executed package delivered but not yet recorded, if they're going to insure title on it, you can take a run at it. But I think the advice that they would get would be, no, let's back this thing up. We have an executed deed, but the person has passed. We couldn't record it before they passed.
Thank you.
Terry Repetto, do you want to unmute and ask your question? Thanks.
Yeah, I have a very young couple who I sold a house to almost 2 years ago. And now they want to get divorced. They are trying to wait until we get to the date that they can close without any tax ramifications. But my question at this point is, as the realtor, knowing that this is coming, is it better to let them go through the process of getting divorced first, or try and sell the house prior to them even going to attorneys?
If you get the place sold while they are still married, their signature, their execution of things gets you where you need to be. Where you get into the spot, Terry, and I would back off, is if either one of them had filed for divorce. You know, if we get into the range of dysfunction in a marriage where people are arguing and talking about a divorce, heck, probably half the marriages in America have been there on a at some time in the course of the relationship. So I would be very concerned with whether or not either one of them had filed for divorce. If they had not filed for divorce and they want to go forward, here's where you get into a problem. You sign as representing both of them, and then they file for divorce. Now you've got a potential conflict going forward. You may need or want to separate them out, but I think you can start that process. If neither one has filed, if they filed, then you're picking one, not the other, and you're going through all the stuff we talked about.
Nicole Pugh, you want to ask your question? Thanks.
Good morning, everyone. Hi, Bill. Thank you for this class today.
My pleasure.
My question is regarding the property settlement agreement and the equitable distribution. So as the realtor that's assigned, should your name be on any of those documents?
No.
Very good. And how do you know, as the realtor, which priority attorney to communicate with? Because each email costs the client money. So how do you determine which head, so that that attorney distributes to everyone else what needs to be done? For example, when the property gets listed, when it's pending, and when it's for sale, so that we're not giving too much information on behalf of our client.
You go to the attorney who's representing them in the domestic relations case, and you get written instruction from that attorney. Okay, and if you're getting two different perspectives on it from attorney A and attorney B, you do nothing until they sort that out. They've got to put their head in the noose, forgive me, as to what has to happen here, not yours.
Indeed. So then it is okay on my behalf, just so that, you know, there's not too much information given on the other party, to just succinctly state as less as possible, just sticking with the facts. You know, it's listed at this point, it's pending at this point, and sales, because I do understand that every email that's sent, if I send it to multiple parties, that's charging the client money.
What, from the attorney's perspective? In other words, the attorney sending? Yeah, but don't, that's not your concern. Don't worry about that. Your job is to protect your client, take the high road, and make sure there's disclosure from your perspective consistent with the property settlement agreement or the court order.
Okay. Thank you.
You're welcome.
Dan Hayden, you're up.
Yeah, something that drives me nuts is I frequently run into people who got divorced 5, 10, even 20 years before. And even though they have an equitable distribution and a property settlement agreement, why do attorneys not include a POA so the spouse that air quotes gets the house can just do that without having to drag the ex-spouse in with an opportunity to stick their hand out?
You know, Dan, probably because they've seen circumstances where things are completely fragmented. Let me give you a simple, good example. I had a closing 25 years ago. A very young title representative who was doing a very thorough job. She did a great job. She was over prepared. My involvement is I was showing up to pick up a check for the bank. The house was being sold coming out of a divorce, and they could not agree on how they were going to do things. There was some back and forth all the way up to the bitter end. We got through closing. There were half a dozen attorneys in the room, myself being one of them. And about 2 hours after the closing, there's no power of attorney involved. The gentleman was asked to come in person to get this done. Rather, they didn't even want to use a power of attorney, or he wouldn't give them one. He comes in and he signed all the documents, was snarky at best. I got a call 2 hours later from this young title clerk, and it was something like, Batman. She was literally in tears. This guy had signed all the documents at closing, Batman. He was refusing to cooperate at all. He was going to try to make a point or just be miserable or vindictive. But he went through that whole pile of things. And, you know, I got my check. I saw the settlement sheet. I'm getting the check. That matched. That's all I had to do. Well, the divorce attorneys weren't paying attention to who was in the room. We're keeping Batman and the former Mrs. Wayne, you know, separated. But it was that contentious. So I think the reason is it's the rare circumstance where they are getting along just swimmingly. And
Well,
even
right,
if it
but
appears to, they
But if
don't.
you get to the point where you've said this partner gets the house and they can decide at that point how to divide the asset, why leave that hand grenade there to deal with 5, 10, 20 years down the road?
You're losing me. The hand grenade being the disposition of it.
The both spouses still being on the deed. Because my clients don't tend to have enough money to afford a dozen attorneys that is closing.
Right.
So it's, you know, somebody was scraping together. They they couldn't refi the house because, you know, economic circumstances.
Well,
And
that's
then-
it. It's some economic circumstance that
But
you'd have to get the permission of the lender to waive the due on sale, because that's a transfer. You get the
well, that's why you put the power of attorney in place. So when they can sell the property and pay off the old loan, you don't have to drag in your ex-spouse that you may or may not be on peaceful terms with. It just seems.
Yeah, I think the better thing to do is at the point of attack to work on the lender and try to get that deed corrected at that point, so you don't have that issue 10, 20 years. I agree with you.
Well, you can't change a deed without the signature.
Well, that's right. So you try to get them to sign off on it now, and you get permission from the lender to drop it. If you need to, you can record a mortgage behind it if it's a collateral issue. Record a mortgage to protect some of the economics on the thing that is satisfied when the payment occurs.
Yeah.
But I would get everything done in the present tense. You want these guys, and a lot of
Well,
things.
yeah, but that's where we run into it. Is I'm not involved in their divorce 9 times out of 10. It's after the fact.
Mm-hmm.
That's
now
where I'm
now you got both of them on. Yeah, I think it's leading
inevitably,
leading
even though the one spouse is supposed to get their percentage, they have their hand out for a little bit more just to get it done when it needs to get done.
I'm with you. I understand the problem, but I also am sensitive to, you don't want to create a power of attorney necessarily that's going to be out there for 20 years with somebody that maybe you're not getting along with. So the answer is the lawyer's got to put their heads together, get the lender to cooperate, get the deed straightened out now. And if there's a collateral situation that has to be established, do it some other way.
All right, Robin Lawhorn, you're up next.
Hi, Bill. In regards to the power of attorney and a seller disclosure, who should be filling out that disclosure, both if the principal is either in an incapacitous state, or they are capable of answering the questions? But that question seems to be coming up a lot, where how do we handle a seller disclosure in regards to a power of attorney?
I would default to the owner. Unless they are incapacitated, in which case the act itself goes into some detail, which we've attached. And I don't think it addresses specifically says transfers by a fiduciary in the course of the administration of a decedent's estate, but it doesn't say power of attorney per se. So I probably would err in favor of them both signing it, but I would not go forward without the seller signing it unless there was a real compelling reason. And even if the seller had to say, I'm signing it, but I haven't lived there. I haven't lived there in 2 years or something to that effect. Over disclose in every circumstance.
Okay.
All right. Jennifer, you had your hand up, you put it down. Did you have a question? Are you good?
It was very similar to Robin's about the seller's disclosure.
All right, thank you. Anyone
While
else
I'm
have a
unmuted-
question?
Oh, I just wanted to thank Bill for the presentation. It was great.
Oh, thank you. You're very kind.
All right, so we did drop links to the materials that Bill referenced. They are in the chat, and those materials will also be linked to the recording of this session, which should appear on our website in the next day or two. Terry, I see you have your hand up. Go ahead.
Yeah, Mary Ann O'Neill has been trying to talk. I'm guessing she doesn't know where the raise hand thing is, so.
Mary Ann?
Yes, I guess I was doing it wrong. I had actually two questions. The first one is very short. And is the letter of testamentary and the short certificate interchangeable? Are they the same?
Marianne, hello, first off. I did see you raising your hand, but I didn't know how to do the recognition thing either. They're two different things. The grant of letters is, you're not going to mistake one for the other. One's a full page with a fancy seal on it, a foil seal on it. That doesn't get shared or delivered to anybody. That stays in the executrix, or the administratrix file. Okay, that's their proof that they have the authority of the court. The short certificate basically says, yeah, there's one of those things out there that gives this person the authority, and here's the only copy you need, Mr. Bank, Mr. or Mrs. Realtor, to go forward on this thing. Okay, so there are two different things, kind of serve the same purpose. I guess at one point in time, all they did was the grant of letters, but they were probably expensive to reproduce. So they said, well, let's put something out that's, it's not even a full piece of paper. It's literally half the size of an 8.5 by 11 sheet. And I forget, anybody done it recently? I forget what the cost is. It's like $2 or $3 a piece, maybe more now, but yeah, they're different.
Okay. So the second question is, I have a friend who got divorced about 20 years ago, and they never had a property settlement. They have lived together for 20 years as divorced people, and he just died. Now, if there's no will, where would the house, the proceeds of the house go?
Oh boy.
He's got 4 children.
Well, there's going to be a contest. First of all, the court should not have entered the divorce without a resolution of the economics. I believe what the court's position would be is they didn't do anything about it, so they're going to look to the key instrument, which in that circumstance then is the deed. What does the deed say about the property?
Well, it says that they took it in tenants of, isn't that when a husband and wife?
Well, the husband and wife will be tenants by the entireties.
By the entirety, okay.
But
That's how they took it.
Okay, the analysis, I think, would be, Marianne, they had it by tenants by the entireties. If that preceded the divorce, and now you have a divorce, I believe the court's going to say, as a matter of law, by action of law, namely the divorce, they were transferred to tenants in common. The argument may be that she's going to argue that they were transferred to joint tenants with right of survivorship. But I think the answer I would expect to have been entered is that they were tenants in common, his half being his estates, her half being her estates under the circumstances. But
So I
that's
guess
the contest.
So the 4 children would get his half,
Well,
even,
that's what
even if there's no
I-
will.
it's going to depend. I don't think I can't give you a definite answer. I'm just trying to give you as quick a thumbnail analysis. I think it's going to go that way, but there's a lot of other factors that could be in play. So you got to tell them they got to get an attorney, and the other side will get an attorney, and hopefully they'll work something out that's not too painful to the families.
Let's hope not. So, Bill, thank you so much for putting this.
Oh,
this-
you're very welcome.
that's been
Paula
fun.
deserves the credit. Paula and Patrick Casey, who, by the way, is a very bright young guy. If you guys, you can always call me, and I'd rather hear from you in advance, certainly. But you can also call Patrick he's a Georgetown grad, Dominic. So I think
We'll forgive him. We'll forgive him.
Yeah, don't hold that against him.
So Bill and Patrick's contact information are in the handouts, and Bill just invited you to make use of that. So please do so. Last call for questions before we end this program. All right, seeing none, I am going to put one more link in the chat, and that is an invitation to our next seminar, which will be on March 13th on why realtors should add rental and leasing to their business plan. So hopefully we'll see some of you then. That'll also be a webinar or a Zoom meeting. And Bill, thank you again for your time and the detail. This was a great presentation, and I look forward to seeing you all again soon. Thank you.
Thanks, guys.